Mr. Is it Mr. Weinstein or Weinstein?
Mr. Weinstein, Your Honor.
Thank you, sir. I thought I had it correctly, but I didn't want to butcher it. Thank you, sir. And I have Mr. Frederickson. Good. I think it's still good morning. All right. Excellent. All right. So Mr. Weinstein is great. He has his microphone muted. Mr. Frederickson, since you are the appellant, as you know, just a quick reminder, you are given 20 minutes to make your argument, and you could reserve up to 5 minutes for rebuttal. So at this time, how much time do you wish to reserve, sir?
5 minutes, Your Honor.
Very good. And the panel is ready whenever you are, sir. Please proceed.
And good morning, Your Honors. May it please the court. My name is Blake Frederickson on behalf of the appellant, Mr. Randy Cattell. And I want to start by perhaps filling in some details on why, before I get into my argument, as to how we got here in terms of the entry of the summary judgment. The July of 2019, there's a hearing on the motion for summary judgment. I was not counsel at the time of that hearing. I joined the case in January of 2020. At the time that I joined the case, there had been a notice of readiness for trial, and there was exchange going on of trial dates. When I took over the case, I did notice that there was a hearing on the motion, well, at least a notice of hearing on the motion for summary judgment. I did not know if a hearing had taken place at that point, but I had reached out to prior counsel, who was Brown and Associates. The attorney who actually appeared at the hearing is an attorney by the name of Kevin Paul. He was no longer with Brown and Associates, and he has been suspended. He lost his law license for I guess his association in a prior law firm. On the same day that I filed, or the next day that I filed the notice of appearance, I also served discovery, which was subsequently responded to, at least the request for admissions were 15 days later. Then on 3 weeks later, prior to the expiration of the 30-day period for the discovery, the order on the motion for summary judgment came around. I was able to speak with an attorney at the Brown and Associates who said that the court took no action. There is no transcript of what happened at that particular hearing, but I just wanted to give the court some background as to how we got here in that 8-month delay. We were under the impression that there was no action taken, and I thought it was proceeding to trial, and the opposing counsel thought it was proceeding to trial, but apparently it was not. Now turning to my arguments, the appellee's case, its theory of standing is based solely on being the holder of a blankly endorsed note. At its most basic level, the summary judgment was improper because there is direct record evidence stating that the holder of the note is somebody other than the appellee. More specifically, the MPS records that are attached to the second affidavit in support of summary judgment state that a Frederick Wynn is the holder of the note and not the appellee. Now, what's also interesting about, to perhaps buttress this argument, is that the Bayview Loan Servicing changed its representative capacity in this case. They initially started as a servicer for First Midway Bank or First Midwest Bank. Later on, that changed by way of a motion to correct Scrivener's error. And setting aside for a minute the propriety of a motion to correct Scrivener's error when you fundamentally change the plaintiff, I wasn't involved then, I'm not sure what happened, but nonetheless, there was an order entered on that motion. But even after the motion was filed and the court the appellee saying that it should have just been Bayview as a servicer, or I'm sorry, just Bayview in a direct capacity as a holder. There's another affidavit that comes out in support of summary judgment in which the affiant signs the document signs the affidavit on behalf of Bayview as servicer for First Midwest Bank. So even after this supposed error was the extent you could call it that, was uncovered, Bayview still took the position, or at least their witness was comfortable signing an affidavit stating that they were still acting as a servicer and not a real party in interest. It wasn't until the third affidavit that the Bayview takes the position that they are in fact a real party in interest, and they're pursuing this case not as a subservicer, but as a strictly as a holder of the note, not on someone else's behalf. I'd also like to point out too that, and this perhaps was lost in some of the briefs, but that plaintiff alleges that Fannie Mae is the owner of the note. That's in paragraph 9 of the complaint. And later in that same paragraph, it also says that Fannie Mae has given the authority for the plaintiff to bring this case. It's not clear whether or not that authority was given to First Midwest Bank or to Bayview. They don't seem to make that distinction, but it is relevant, and I'll circle back around to that.
Mr. Fredrickson, if I may, I understand the facts you're laying out for us, but what are we to do without a hearing transcript?
I think that under normal circumstances, it's unquestionably a little bit more challenging without a transcript. That would be disingenuous to suggest otherwise. However, when we're dealing on a summary judge, what we're really missing is what happened at the summary judgment hearing. That's what we're missing. But the only thing that would have happened at the summary judgment hearing would perhaps be relevant to the second issue on appeal, which is the discovery, whether or not the judge closed discovery, whether or not he said, I want you to submit orders, I'm taking no action, I'm denying it, we're not sure. But as to the fundamental arguments, there wouldn't have been any evidence submitted there, right? Just unsworn statements of counsel, legal argument. And regardless of what was said at that particular hearing, the material issues, the factual dispute is still there.
But Mr. Weinstein's client is telling us that what was presented at trial, the note and the allonges are identical to what was attached to the complaint and demonstrate an unbroken chain to establish standing. And I was just wondering if we had a transcript that may or may not have shed light on what the lender is saying.
Well, perhaps if there would have been a transcript, but even if because no testimony was taken, there would have to have been a transcript that would have had testimony by a qualified witness explaining why the holder of the note is reflected as someone different in their records, as opposed to who's the named plaintiff. And that couldn't have happened, regardless. And I think more specifically, what Your Honor is asking about is the Ortiz presumption, where Mr. Weinstein is arguing that on behalf of his client, that the notes are the same as the copy that was filed attached to the original complaint, as well as the copy that was submitted, at least in the notice of filing. There's really no direct evidence to how it appeared at the time of entry of the judgment, but we'll have to assume that it was as it appears at the time of notice of filing the original, which I think was in 2016. The problem there is the Ortiz presumption. One, we don't believe that the Ortiz presumption applies, because the differences in the second allonge and small redaction may be one thing, but what happens is it starts later down on the page, and yes, all the same contents there, but the linchpin in Ortiz is that if you had the original, it would look the same. Not that you did.
Not if you just go ahead, Judge Lawrence.
But you're telling us now, I don't know what explanation may have been made by counsel at the hearing. And that's what my fundamental concern is.
Yeah, and I guess my response to that would be, it wouldn't have mattered particularly for the issue of the holder, because there couldn't have been any explanation that the court should have properly considered. Because the only thing he could have said was, well, this was an error. The lawyer would have said this was an error. That would have been inadmissible. The court shouldn't have considered the unsworn statement of counsel.
Mr. Fredrickson, what troubles me about your assertion that the Ortiz presumption doesn't apply is just because the allonge was photocopied halfway down the page and attached to the complaint. I mean, I've got what was attached to the complaint and presumably the original that was admitted or submitted to the court. They're the same. one starts halfway down the page, but they're the same. And so to try to suggest that because one was photocopied lower on the page means the Ortiz presumption doesn't apply. Do you have?
Yeah.
What support is there for that?
Well, Ortiz and its progeny, and really there's a litany of cases cited by Mr. Weinstein that say that support that idea of the Ortiz v. PNC. But the key is that it says absent evidence to the contrary. That presumption is absent evidence to the contrary. Here we have direct record evidence to the contrary. We have a computer printout that says that the holder is not Bayview. It's in fact Frederick Wynn. So,
but isn't the holder whoever possesses the note endorsed in blank?
That's right. But what is going to be relevant is there are two different times, right? At the time of the filing of the complaint and at the time that judgment is entered. Mr. Weinstein's client is relying upon the Ortiz presumption that that Bayview was the holder of the note at the time of filing the complaint. The problem is their documents say otherwise, directly say otherwise. So that's the evidence to the contrary where we get past the Ortiz presumption. And so that's why we argue that it's not, even if this court were, as Your Honor is suggesting, saying, well, it's in our opinion, it's the same or it's close enough. Even if it's that, you still fall back on, well, there's evidence to the contrary. And again, we're on a summary judgment standard. I'm sorry, did you say, I didn't hear.
Actually, Judge Rothstein, Joachim is the one that asked the same question that I had in my mind, and you've already responded to it, Mr. Ferguson. Thank you.
Okay. And if I could turn a little bit to the discovery issue that was raised, the majority of the cases that are cited by Appellee deal with cases in which the appellant was attempting to shoehorn or to delay or to stall summary judgment. So the courts look back and say, even this court has said, look, you had opportunity to do it and you did it. You decided to do it right before summary judgment. In this case, we don't have that. I had no reason to, I don't think the parties did either. Any of the parties believed that the court was going to enter summary judgment when it did. There was no orders submitted. There was no indication that was going to happen. In fact, the indication was the opposite, that it was going to be set for trial. There was discovery served by prior counsel back in 2016. The responses are not on the record. That this particular law firm doesn't act more like in the federal system where they just do a notice of service and there's no actual filings, which is common for interrogatories, but not for the other ones. And so there's no responses. And my experience told me that it would be better just to start immediately, go ahead and serve it now. The plaintiff didn't have any objection. They responded. They just didn't get a chance to respond to the other two because the court entered summary judgment prior to the expiration of the 30 days. There seemed as if the issue of whether or not there was prior discovery that would have covered this also, I believe, is addressed when the representative capacity of the plaintiff changed from the beginning of the case. There's a 2013 case, in 2016, and then in 2017, when the supplemental affidavits are submitted, Bayview is now acting as a different party. In addition to that, we have the submission of additional evidence that suggests that there's a completely new holder of the note, or that the holder of the note was not Bayview. And for those reasons, as well as the preservation of, if I could just briefly address the preservation of the argument for appeal, Mr. Weinstein is attempting to make a distinction between an argument that in the affirmative defenses, as well as the motion to dismiss, as well as the specific denials in the answer and affirmative defenses, that the appellant did not raise the issue of standing as a defense. More specifically, that appellant did not argue that the that Bayview lacked possession of an original note endorsed in blank at the time of filing and at the time of what's argued at trial, but in this case, summary judgment. And Mr. Weinstein points to, he says, well, they did not make that same argument. They made the argument that there's evidence to the contrary, that someone else is the holder, and that there's discrepancies in the note. Respectfully, that's a distinction without a difference. That's the exact same argument. We're arguing that their evidence is inconclusive, if not contrary, supporting a certain position that we have specifically denied. The Applegate, I'm
Mr.
sorry.
Frederickson, just want to let you know, I'm looking at the clock. You're about to get into your rebuttal time. Feel free to go forward if you'd like, but I just want to alert you to that.
Sure. And just briefly, the Applegate and Zurak cases that were cited, Applegate deals with a non-jury trial. That's on two different issues. One, an evidentiary issue, and there was an insufficient record as to what the objections were, what arguments were made. And then the Zurak case, while it was summary judgment, there was absolutely no pleadings. There was a default situation. There was no answer. There was no discovery. There was no motions of opposition. There was no affidavits. So it was impossible for the court to make a ruling because there was insufficient record as to the issues preserved on appeal. And for those reasons, as well as the arguments in the brief, we argue that the court should overturn the entry of the motion for summary judgment and subsequent final judgment of foreclosure. And I'd like to reserve the rest of my time for rebuttal. Thank you, Your Honors.
Just so you know, sir, you have 4 minutes for rebuttal. Very
Thank
good.
you.
And I'm going to ask you to mute your microphone now. All right, Mr. Weinstein, we're ready for your argument. So whenever you're ready, please proceed.
Thank you, Your Honor. May it please the court. From the appellee's position, from the bank's position, this case is one in which Mr. Frederickson has done as laudable a job as possible of attempting to litigate this appeal as he would have litigated the trial court case where he counseled at the time, but he was not. And so we have the record that we have, and the record that we have has an affirmative defense that simply says that plaintiff lacked possession of an original endorsed note when it filed the lawsuit. We have the filing of an original endorsed note by the plaintiff. We have a summary judgment hearing that occurred without a transcript. We have no way to know whether the appellant argued that affirmative defense at the hearing. And we have no way to suppose that the appellant argued the argument on appeal, which is different from that argument at the hearing. In 2018, this court issued its opinion in Johnson versus Deutsche Bank, Florida 2nd DCA opinion from 2018, in which this court said, quote, presenting an adequate record, one that demonstrates not only what evidence was presented below, but also which arguments were preserved, remains the appellant's burden in an appeal of a summary judgment, unquote. Here, Mr. Frederickson has attempted to state that what argument was made at the summary judgment hearing is irrelevant because it's a non-evidentiary hearing, but this court clearly stated that's not the case. There are times in the summary judgment context where a transcript is necessary in order to demonstrate the preservation of an argument. And so in the reply brief that was filed by Mr. Frederickson, he references a case called Benz. We filed a notice of supplemental authority of a case called Winchell that this court put out afterwards, which cites another case called Maynard, which qualifies Benz. But beyond that, the citation in Benz was for the purpose of explaining to this court that the defendant or the appellee could, under certain circumstances, raise the issue of standing without raising an affirmative defense. Even if that's true, it would have to be preserved. Here, it was not because we don't have a transcript. And so that transcript issue really is fundamental. And it's independent of the fact that the affirmative defense is different than the argument that's raised on appeal. Those are two separate bases to find that there was a lack of preservation of the issue on appeal. But those two issues are also related because it seems particularly apt that one would need a transcript when the argument that one is attempting to say was made at that hearing is different from the affirmative defense. Beyond that, there's just no genuine issue of material fact. Every single word, letter, number, brushstroke on the allonge that is attached to the complaint and is a part of the certification that was filed at the beginning of the case is the same as every word, letter, number, and brushstroke that's on the copy attached to the original filing, notice of filing the note and mortgage. The original note is in the exact same condition as the note that as it was attached to the complaint and the certification. No difference, thus the Ortiz presumption applies. What's more, Mr. Fredrickson has attempted to impugn the ability of Bayview to proceed on its theory that it was the holder of the note. If you look at the complaint and you look at each motion for summary, you look at the motion for summary judgment, you look at every affidavit, in each one, the plaintiff, Bayview, claims that Bayview is the holder. The entire theory of the case from Bayview's perspective from the beginning of the case is that Bayview is the holder. Bayview, at summary judgment, proceeded on the theory that Bayview was the holder. The holder of a note, as Judge Rothstein-Yoakum explained, is one who possesses an original note that is either endorsed specifically or endorsed to blank. Here, we have a note that has an unbroken chain of endorsements and allongements that ends in blank before the filing of the complaint. That copy is the same as the original note that was then filed by Bayview. And so throughout the entirety of the case, Bayview maintained and demonstrated that it was the holder of the note. The owner of the note is irrelevant to a determination of standing when a party is attempting to enforce a note based on its status as the holder thereof. Plaintiff demonstrated that it was the holder of the note. What's more, the representative capacity of the holder is also irrelevant to the claim of standing, because the only issue is whether the person has standing to enforce the note. And if that person or entity is a holder, they do. Bayview demonstrated unequivocally that it was the holder of the note. With regard to the discovery issue, the discovery in this matter was filed after the motion for summary judgment was filed. It was filed after the motion for summary judgment was noticed for hearing. It was filed after the hearing on the motion for summary judgment. The fact that Bayview anticipated that the case may still go to trial because no order on the motion for summary judgment had yet been entered does not mean that that discovery can thwart the summary judgment itself. It was filed too late to do so. And there's no reason to state otherwise. The case law that we cite talks about the fact that if it's filed after the notice of hearing, then summary judgment is proper. Here, not only was it filed after the notice of hearing, it was filed after the hearing took place. There was no motion to continue summary judgment based on the pendency of discovery. And again, it's unfortunate that Mr. Fredrickson was not able to litigate this case in the way that he would have wanted to were he counsel from inception, but that doesn't change the record that we have on appeal. Barring any questions from the judges, I will see the rest of my time.
Very good. Thank you, Mr. Weinstein. And if I could trouble you to mute your microphone.
Yes,
Mr.
Your Honor.
Fredrickson, you have 4 minutes for your rebuttal, sir.
Thank you, Your Honor. I wanted to briefly address Johnson, the Johnson opinion issued by this court. The important part about Johnson is that relatively comparable facts to this case. The court found in Johnson, the ultimate holding was that there was a sufficient record on appeal to make a determination as to whether that the argument was preserved. You could treat Johnson, and I think that maybe that litigants have since then, as a potential, not necessarily guideline, but a warning that, look, there are circumstances in which we're not going to be, even though it's summary judgment and it's not evidentiary, and the Shahar case says that in the general rule is that a transcript would not be necessary in an evidentiary proceeding. But the only requirement of the appellee is that they present a record sufficient for this court to make a determination as to the issues on appeal. And we've done that. The issues, the argument is, in my opinion, almost identical about the standing issue. It's also raised in the motion to dismiss. And Johnson, to the extent that Mr. Weinstein's client is relying on Johnson doesn't stand for that principle. Johnson stands for, yes, in fact, there's a sufficient record. And the facts really aren't that different in Johnson as they are here. They're relying on what was in the pleadings, because the motion for summary judgment, there would have been no explanation and no evidence presented that the court should have or could have considered that would have made any sense, that would have clarified the direct evidence we have in opposition, which is so critical in this case, because that's why Ortiz does not apply. Even if
the evidence of that Wynn might have been the holder?
For the evidence stating that Frederick Wynn is the holder. Yes.
Let me ask you this: if it was so important and so critical, and I just pulled up the record on appeal and ran a search for Wynn, it is only mentioned in that one document. It's on page 369 of the record. that when is the holder is not asserted as an affirmative defense. It's not mentioned anywhere else in this file. And so it seems to me and that this issue has been raised for the first time on appeal by somebody who has gone through the file looking for contrary evidence or something that should have been raised or might have been raised below or presented below or argued below that was never argued below, because there is absolutely no indication that any of this was argued below this one reference.
I agree with Your Honor that we don't have, obviously we don't have a transcript. So the words that came out of counsel's mouth at the hearing, we can't know. But what we do have is the summary judgment evidence. And while I guess I respectfully disagree that because it's only mentioned once, that it is somehow less important.
I guess what I'm saying is you're making your summary judgment argument for the first time before us. This is not just a de novo review. This is effectively a new motion for summary judgment in front of us, because you're saying, look at this contrary evidence. And is that a correct assessment?
And Mr. Fredrickson, go ahead and respond to that. And after that, you would have exhausted your rebuttal time. But go ahead and please answer the question.
No, I don't think it is, because the argument as the challenge to the standing based upon the lack of holding was always there. It was always there. Mr. Weinstein is correct. The Bayview, at least it was in a non-representative capacity, but nonetheless claimed to be the holder. They've always said that. And Mr. Cattell has always challenged it. So that argument was always there. And I thank you very much for my time. Thank you.
Thank you, Mr. Fredrickson. Thank you, Mr. Weinstein. What I'm going to do now, I will actually be leaving because we have Judge Lucas will be entering. We'll have a panel change for the